With that, let me read an excerpt of something that was released as allegedly a paraphrase of Mr. Coates' statement on his going away party and ask if you can confirm whether it was said or not. Quote, selective enforcement of the law, including the Voting Rights Act on the basis of race, is just not fair and does not achieve justice. I have had many discussions concerning these cases. In one of my discussions concerning the Ike Brown case, I had a lawyer say he was opposed to our filing such suits. When I asked why, he said that only when he could go to Mississippi, perhaps 50 years from now, and find no disparities between the socioeconomic levels of black and white residents, might he support such a suit. But until that day, he did not think that we should be filing voting rights cases against blacks or on behalf of white voters. Did you hear that statement?
Yes, I did. There's more.
Well, in your experience at the department, have you had similar statements from? Have you heard similar statements from attorneys about a reluctance to pursue voting rights cases in which the defendants are black or the victims are white?
Over and over and over again.
I sense that you, well, since you just mentioned a list, why don't you tell us about it?
Okay. Mr. Coates was told that particular instance on or around when they were doing coverage in Noxubee in 2003. If Mr. Coates were here, he could tell you about this firsthand, but it was conveyed to me by Mr. Coates. In the 45 years since the Voting Rights Act was passed in 1965, the department has brought hundreds and I believe hundreds of cases to protect African Americans, language minorities, and so forth. There are only 2 cases that the department has brought to protect white voters and have African American defendants. One was the new Black Panther case, and one was U.S. v. Ike Brown. Those 2 cases provide the illustrations that I'm going to go through to make sure that all of these particular instances are out in the record. And as to why I came to the conclusion in my article that this is open and pervasive. For example, and this is one of many, an attorney told Mr. Coates after the U.S. v. Ike Brown case was filed, he came to Mr. Coates, and attorneys, people refused to work on the case. They literally said, I'm not going to work on that case. I refuse to work on the case.
How can that happen? And as a supervisor, that he had to accept that? Or?
This is how the Civil Rights Division is. Listen, the housing section won't even have a office picnic because the word picnic is viewed offensive. Okay? This is the Civil Rights Division. Anybody who's been there can tell you this. And anyone who's there now knows this is the truth. You just work around it. You work around it. So anyhow, this person comes to Mr. Coates and he says, I'm not going to work on the case because I didn't join the voting section to sue black people. So this happened right after the case was filed. People refused to work on the matter. One of the most compelling examples of this hostility, and I'll get to more conversations in a second, is how the department refuses to enforce Section 5 of the Voting Rights Act on behalf of white victims. Section 5 is the pre-clearance provisions. It's sort of technical, I understand, but it's what allows the department to block implementation of voting changes. It's a very important part of the Voting Rights Act of 1965. But I will guarantee you, in 45 years of this law's existence, not only has there never been an objection on behalf of a white victim, there hasn't even been the analysis. They don't analyze this. It isn't done. There's hostility toward even opening up that can of worms. And I'd like to submit for the record this submission that just came in. This is from Noxubee County, Mississippi, the place where Ike Brown was found to have discriminated against the rights of white voters in 2007. This submission is asking the department to approve Mr. Brown's right to block voters from voting. That's what this submission is, based on their ideology, whether they've supported Republicans. Now, the federal court in Mississippi found that that particular behavior was indicative of racial intent, an illegal racial intent, and found in favor of the United States. Well, right now, we'll know by July 14th of this year whether or not what I'm saying is accurate about the department, because this submission should be objected to. The department should take the ruling in the U.S. v. Brown case and lodge an objection to this. But I'll bet you that's not what's going to happen. And everyone's going to be able to see that they're not going to object to something they should be objecting to. They have a couple of options. They could pre-clear it. That would be an embarrassment because the federal court already found that it violated the law. They could ask for more information under the statute, but that's a delaying tactic that would only give them until September 14th to decide. They could do what's called a no determination letter, which is essentially a cop-out saying, well, the federal court stripped you of power to run the election, which they did because he was so bad. So you can't make this submission right now until you're back in charge. He's still going to have these rules in place in Mississippi after he's back in charge. So the no determination letter would be a cop-out. Another cop-out would be a Section 2 case or an offensive attack in federal district court against Ike Brown for this submission. That would be to go to the judge with all those higher standards of proof, of preponderance of the evidence, and a federal judge and all those other risks that are involved with going to court in a Section 2 matter. If the department chooses that, it will be more evidence they are unwilling to lodge an objection under Section 5 to this submission simply because it's white victims. Now, how do I know that they're not going to do this? Because I've talked to the victims in the last week. I've called the people in Noxubee, Mississippi, and I've said to them, has the department been calling you like they always do when a Section 5 submission comes in, the minorities in the area? No, we haven't heard a word. You're kidding me, right? They haven't called about this submission, which targets them. Because the department doesn't want to use Section 5 to protect white voters. And we will know by July 14th whether or not they have lodged an objection to this particular submission. My guess is they'll either say no determination or they'll try to go to federal district court, which of course both are cop-outs because of the risk involved in federal court, the higher standards. Mississippi has a whole bunch of loyalty oath litigation that also complicates the issue that I won't discuss here. But it's a loyalty oath. And it's a racially based loyalty oath that the department could object to tomorrow, but won't.
Can we submit that?
Yes, for the record, Chair. It's accepted.
Okay.
Thank you. Is there any more items on the list that you
Oh,
want?
yes, there's plenty.
This is the time. Why don't
Okay. At one meeting with the chiefs of the Civil Rights Division, including the chief of the criminal section, Mark Kappelhoff, and other various leaders of the division, Mr. Kappelhoff made a statement where many people were present that talked about the U.S. v. Ike Brown case, and he said, quote, "That's the case that has gotten us into so many problems with civil rights groups," unquote. Mr. Coates complained to the acting assistant attorney general, Grace Chung Becker, and said that that's a totally inappropriate statement. It is my understanding, and if Mr. Coates were here to testify to comply with the subpoena, he would tell you that Mr. Kappelhoff was told that in no uncertain terms should we be criticizing cases that the department has decided to bring, and in fact in this case won. But it shows you that not only are people in the department hostile to the case, but for reasons I can't even begin to explain, so is the civil rights community. It's a very short-sighted view. Now, there's more. In 2003, when the department first started monitoring the behavior in Mississippi, in U.S. v. Ike Brown, we do election coverage, a deputy named Robert Kengel, who was the voting section deputy, told Mr. Coates while they were going down traveling, I think at the airport or near it, he said, "Can you believe we're being sent down to Mississippi to help a bunch of white people?" Again, Mr. Coates, if he were allowed to comply with the subpoena, would tell you this and tell you more. Other people told me in the section when I was assigned to the case that they came and visited me, and they echoed the statements that you made earlier, that until blacks and whites achieved economic parity in Mississippi, we had no business bringing this case. This obviously was rather discouraging to hear that people didn't want to pursue a case that you were on. There's more. And it goes to the J memoranda process in the U.S. v. Ike Brown case. And this is very, very important to understand because there's other witnesses to this too. Mr. Coates prepared in 2003 a J memoranda, memorandum about the Noxubee case. He included an extensive discussion as to why a civil case should be brought against Ike Brown in Mississippi and why it was very good to bring a civil case. The chief of the voting section at that time was a man named Joe Rich. Joe Rich forwarded a recommendation to closely monitor the situation, not sue, closely monitor, and omitted all of the discussion that Mr. Coates made about why a civil lawsuit was the best course of action.